Good afternoon, DAR members. Give us just a moment. I want to make sure everything is good to go. All right, good afternoon, everyone. Thank you for joining our session today on DAR's new and updated standard forms. I am Wesley Stefanik. I am the Chief Executive Officer of the association, and I'm joined here today by Matt Lafferty, DAR's Chief Operating Officer, and Mr. Bruce Plummer, DAR's Forms Committee Chairman. We're also joined on screen, but not here in Dover, with Andy Taylor, our association's legal counsel. We do particularly thank Andy for joining us from his family vacation. So thank you, Andy, for taking the time to contribute to today's session. If you're still new to Zoom, which I hope after 4 years of us living in this world, you're not, but if you want to change your view of the screen, we're going to be sharing documents. Hit the button at the top that says view. You are able to change your screen and modify it for whatever you're looking for. Please note that this session is being recorded and we'll have it uploaded and sent out early next week. So not today or tomorrow, early next week. There is also time for questions today. I'm going to ask a favor though. There is in the chat box, you have the option to select a person to send a chat to. Please send it to questions. It says to and then hit questions. Fill that out when you want to submit chats or any questions or suggestions, whatever. Please submit it there. I'm going to ask one favor. Please be very poignant in your question. Please do not add commentary, as it's important for us to work through the questions efficiently. It's just easiest if the questions are simple, and that's that. You know, we as DAR staff, we know, and I could probably speak here for the local association staff as well, that none of this has been easy. We understand that. We know there's been a lot of fear, a lot of uncertainty, and countless questions, that's for sure, about what is happening in the industry. We hope these Zoom sessions over the last 8 months or so and the communications that we have sent out have all been useful to you. Yes, time has definitely not been our friend, unfortunately, but our diligence in fully understanding the known factors we face has been our priority. If we're going to put out communications and services to all of you, including these forms, we want it to be the best that it can be with the information known. We have received feedback ranging from thanking us for being forward-thinking to comments that we are slightly out of touch with the realities of the industry. Please continue to provide that feedback, whichever direction that is, particularly on the forms. Please submit the comments via our website. I'm going to post the link in just a moment when I turn it over to Bruce, but if you go to the forms page on the DAR website, delawarerealtor.com, there is a suggestion comment box. Please put any comments or suggestions you have on any of the DAR forms. There's over 90 in our library, so please submit them there. All the comments, they are reviewed by the Forms Committee in a timely manner and will be incorporated as appropriate. We hope today's presentation explains why we believe the forms here are presented that are the best and safest, and dare I say, forward-thinking on purpose. Before I turn over the rest of the session to Bruce and Andy, I do want to mention one item unrelated to today's purpose. As many of you saw, our annual convention and trade show registration opens on August 1st. Please visit delawarerealtor.com and click the link at the top for the convention to learn more. The event will be a full 2 days here at the Bally's in Dover. We'll have expanded CE offerings and some fun for everyone. The trade show will actually also be 2 days this year. Usually it's one, it's going to be 2 this year. With this new location, we checked off nearly every ask that was requested from us based off the survey we conducted last year. We hope each of you sign up, come down, network with colleagues across the state, and learn together and take time to get to know each other. With that, please know that the forms Bruce is about to present will be available in all forms databases that we license with next Wednesday, July 31st. That includes Zip Forms, Dotloop, DocuSign, SkySlope, and Brokerment, as well as the DAR website. It's unfortunately not immediate, as it takes a bit of time for the providers to upload and format to each database, which is why there is a slight delay, unfortunately. Because we know that only gives everyone a few days, and many have been preparing and training over the last few months. If there is an immediate need to use one of these forms, you may actually find the final versions as fillable PDFs on the DelawareRealtor.com website. I'll put the link again in the chat shortly. You'll have to sign into your account to access them, and that link that I'm going to provide provides all the forms provider options, as well as the suggestion form box that you can submit any ideas or questions or whatever through. So keep that in mind. So with that, thank you all for joining us today. This is one of our highest member count Zooms in a little while. I appreciate you all taking the time to learn. And with that, I turn it over to Bruce Plummer.
Thank you, Wes. Welcome, everyone. I want to first off let you know of the folks that serve on the Forums Committee. We have 2 representatives from each county. We have from Sussex County, myself, and also Camilla Conlon. From Kent County, we have Tom Burns and Bobby Slagle. And from Newcastle County, we have John Ford and R.T. Christopher. Of course, we have our legal counsel, Andy Taylor. Wes Taylor, our CEO, has sat in on most of the meetings. And we would be lost without Matt Lafferty, who has been just an enormous asset for us in doing these forums. I want to first off say that a couple weeks ago, we did a presentation like this. Many of you were there. If you weren't there, that presentation is recorded. You can go to the Delaware Association of Realtors website and go into the video library and actually watch that presentation. In that presentation, we went over the new listing agreement and the new buyer/tenant agency representation agreement. Those agreements, for the most part, have not changed. The only change that's been made to that is in the listing agreement, and I'm going to show you that in just a second. So I'm not going to go over today the listing agreement in its entirety with all the changes or the buyer/tenant agency agreement. You can watch that video at your leisure. The only change from that video has to do with the listing agreement. So I'm going to share my screen right now, and I'll show you where we made a slight change. You should have popping up a copy of the listing agreement, and I'm in section number 10, which is compensation. And just below that, we had section 11, which is seller concessions. It says seller concessions may be offered by seller to assist buyers with closing costs, but are not required. Seller authorizes listing broker to market seller's willingness to consider concessions. We changed that wording just a little bit. Willingness to consider concessions to be paid towards buyer's closing costs at settlement with an acceptable offer. And you've got a yes and no box. Now that was there before. We just added 1 or 2 words. What we removed was the section that came underneath of it. There used to be a provision where you would put there was a blank line. It was optional, it was not required, but there was a blank line where a seller could put the percent or flat fee of concessions that they were offering. We have now intentionally removed that. And we've removed that because we think it's too easily confused with and going to be used to by agents to put in their buyer broker compensation there as a concession and put in an amount. And that's really what we're trying to get away from. We were going to release these forms a couple of weeks ago, the first 2 that I mentioned to you. And then, of course, we held back on that and delayed that release. And that's because of things that have happened in California. And in California, they're dealing with investigations and reports from the Consumer Federation of America, which says that their reports or their listing agreement or buyer agency agreement are too convoluted, too legally complex, too buyer friendly, too easy to get, or too hard to get out of as a client. And they're also dealing not only with the Consumer Federation of America, but they're dealing with our friends, the Department of Justice. And I think a lot of you don't realize we've got the NAR settlement. You may have been keeping up to speed on that. But we've also got concerns as a Forums Committee with the Department of Justice. And they have a much more far-reaching, restrictive approach than the NAR settlement agreement had. And just so you not know why we've taken the approach in our forms that we have, we've tried to comply with all the Department of Justice requirements because we believe now that the settlements have been reached with NAR and the big law or the big real estate firms and franchises, et cetera, totaling now in the neighborhood of about 1 billion with a B dollars in settlements when you start adding them all together. That's counting NAR's 418, then you add all the others. Last time I added them, it was only just shy of 1 billion, and there's been, I think, 2 settlements this week since then. When you look at all that, their next target of the Department of Justice, we believe, will probably be state associations or local form providers. And so we have taken the cautious approach. We have done everything we've done in considering the Department of Justice wishes, and we expect to be in compliance with their wishes. So that's why we've taken this maybe more extreme approach, but the more cautious, we think the correct approach and the one that's safer and going to protect us and the association. And we recommend that you do the same. So we have, in the listing agreement, we have removed under seller concessions, we removed the amount. Now, if a seller wants to give a concession of $5,000 for a roof repair or something, there's a additional term section here. You can put it in there. But we didn't want agents going in here and using seller concessions and using this section, if you would, to start offering buyer broker compensation through this section. So that's the only change we made to the listing agreement from the last Zoom meeting we had a couple of weeks ago. I'd encourage you, if you did not see that Zoom, I'd encourage you to do so. Andy?
So, folks, this pretty much summarizes the DOJ part right here. I'll read you the headline from this. DOJ lawyer, no offers of compensation anywhere. That pretty much sums it up right there. So, as Bruce said, we're taking the cautious approach of taking out the blank for the dollar amount or percentage amount of seller concessions. Later in this presentation, we will talk about some, as we see it, nuts and bolts about how to implement all of this and perhaps some of the pointers for some conversations you'd be having with sellers and buyers. Okay. Thank you, Bruce.
Yes, absolutely, Andy. And for those of you that have been keeping up with the NAR settlement agreement, I would encourage you, if you're not up to speed on the Department of Justice investigation, that's where you need to be focusing right now, because that's more far-reaching and restrictive. And that's why we've done what we've done. And we think we did a pretty good job with it. We actually, when we did this document originally, we talked about the possibility of having to remove the language that we removed. So we were prepared for it. And now we pulled the plug and actually removed it. So yeah. I'm going to stop sharing the screen of my listing agreement and now go into some new forms. But I'd encourage everybody to look at that old Zoom meeting in the video library. Andy, did you have a comment?
Personally, I hope that the Department of Justice files what's called a statement of interest in commenting on the proposed settlement agreement from the 4 cases that are covered by the settlement agreement. Because then we'll know more of what we need to deal with and hopefully, avoid further problems going forward. So as Bruce said, we've done the best we can at this point. And, we won't be surprised if the Department of Justice files a statement of interest, which might not be till October or November. And we'll see if we need to make some further changes at that point.
So for those of you that have listings currently that are not under contract with a settlement occurring before August the 14th, because August the 14th, the NAR settlement is August 17th, but Bright is making a change in their system on August 14th. And as of August 14th, there'll no longer be any offer of compensation on the Bright MLS system. We'll talk about that more going forward. But for listings that you have currently, rather than going back and getting a brand new listing agreement, which now addresses all these things we're talking about, that's an option. But rather than do that, we have created what we call an amendment to exclusive right to sell listing agreement. So this is an amendment to those currently active listings that are not pending with a settlement occurring before those that are not pending. It basically goes back and it amends the current listing agreement that they have with you. And it gives a little history here. I've highlighted some important parts. It lets the seller know that on or about August 14th, 2024, the Bright MLS system will remove from its active listing fields all references to any amount of buyer's broker compensation being offered by a seller or listing broker. In addition, a new field will be added to its active listing fields for seller concessions. So, because of that, we've got to make changes to our current listing agreements, those that are not pending. So therefore, effective on, and you would put a date, you could put today's date or whatever date it's being ratified, or if you leave it blank, it will default to August 14th, which is the date that MLS, Bright MLS makes its change. The above referenced listing agreement will be modified as follows. And here's what it says. Number one, it deletes the brokerage fee section, the old compensation that we had in our current listing agreements. It deletes that and replaces it with language that mirrors what we have in our new listing agreement that we're rolling out next week. And that's all it does. It does away with the old compensation language. It says, now here's how it works. And I'm not going to go through this section in great length. It's basically just taking the listing agreement, says, here's what it says now. We no longer offer buyer broker compensation. Now, then it has section 10, which is cooperation in the current listing agreement. It deletes it and replaces it with how our cooperation section currently reads in the new listing agreement. And then it has a place for seller concessions, yes, no. And once again, it has the same language that's in the current listing agreement. So we took out the old part that didn't apply, that we didn't want in the listing agreement, put the new in. You don't have to go back and create a brand new listing agreement unless you want to. You can use this modification agreement, but you need to get this, or I encourage you to get this modification agreement done before the 14th of August. Certainly before the 17th, or you'd be in violation of the NAR agreement. There is an additional terms section here, and this could be if you wanted to change something else. While we're modifying the listing, suppose we want to modify the price. Suppose we want to modify something else. Maybe we want to extend it. We could do that at the same time. Use this form for those changes. So this is a brand new form. It'll be available as of next Wednesday, and as Wes said, it's even available now on the DAR website. I think you should get to work on this right away, would be my recommendation. So I'll stop sharing that screen and take any questions on that particular form while I'm loading the next form.
Yeah, so we got a couple of questions right off the bat. Can you please clarify that if a listing is pending and settles after August 14th, does this amendment form need to be used?
Do you want to handle it, Andy?
Yeah, no, if you have the listing in place, you have the agreement of sale already signed, it just hasn't settled yet. You do not need to go back to modify your listing agreement. We recommend that buyer's agents prior to August 14th, that if you have a property under contract already, go on the MLS and do a print screen or a screen share of the part that shows the compensation offered to the buyer's agent, because that would still be in effect for properties that are under a fully ratified agreement of sale and just haven't settled yet. But that information is going to go away on August 14th off the Bright MLS. So do a print screen or screen share, a screenshot to make sure you share that information, so you'll be sure that that's the compensation that would be paid at settlement.
Just a couple Bright specific type of questions. I'm going to ask all of them right away. How does this change integrate with Bright's new concession categories? Is active under contract the same thing as pending? Let's start with those guys.
Well, the concessions, Bright will be doing away with the cooperation or broker compensation section altogether. It will now have a concession field. It'll have a yes, no. You can just put yes, no. You don't have to put any amount. I think their field is still going to have an amount, where if a seller were in our listing agreement under additional terms, were to say, I'm offering a $5,000 settlement credit for a roof repair or for new windows or something like that. You could put that in their field, in the Bright field, if you had it authorization to do so in our listing agreement. But I think too often agents want to confuse the broker compensation with concessions. A concession is any kind of closing cost, which could include broker compensation, transfer tax, attorney's fees, title searches, etc. And so hopefully that answers the question. But we want to make sure agents understand the difference, and we have taken out the co-op broker compensation on the listing agreement.
I'll just mention one thing in particular with Bright MLS. While we get their updates here at DAR, and obviously they're incorporated into conversations with the Forms Committee, we have kind of a disconnect as a state association from Bright MLS, just so you are aware. I will note that one of our members engaged with Bright MLS has made us aware that as of June 12th, the concession fields were supposed to be on and working in Bright. But Bright is aware that these fields are not working correctly. So just know that, but that we're not going to dive too much more into that conversation here today, as there's more forms that we have to focus a little more time on.
My understanding also is in Bright, after the property closes, if the agreement of sale provides for the seller to pay the buyer's agent on the buyer's behalf, that there is a field in concessions where you can put buyer agent compensation, you can put repairs, you can put other things, so you can itemize it. We're trying to make sure we keep the concessions and the brokerage compensation separate in everybody's mind. But you'll see when we get to the sales agreement, another reason why we're doing that, and that has to do with interested party contributions. It's separate. It's not a concession, the buyer broker compensation. So we'll talk about that as we get ready to share the agreement of sale, which is a brand new form that you've not seen yet. Hopefully you can see that on the screen now. Now, you want to read these forms. Don't just take this seminar today and think you've got all the changes, because there have been other things change other than just things relating to the NAR settlement and the Department of Justice investigation. While we were at it, we fine-tuned some other things. And you'll see I've highlighted those in purple, or highlighted them here on this screen that I'm sharing. For instance, it says, this is the new agreement of sale. All sums deposited by buyer prior to time of final settlement should be placed in a non-interest bearing escrow account with, it used to say the listing broker. Now it says listing brokerage organization, referred to as listing broker, or buyer's brokerage organization, referred to as buyer broker. We know a lot of times the buyer's broker holds the deposit. That's not our recommended default. That's not going to be the default in the contract. But to accommodate that, it's now a checkbox. You need to check one or the other. Is the listing brokerage holding it, or the selling office, buyer's agent, holding it? If you don't check either, then it continues. It does have a default. It says in the event no selection is made, the deposit will be held by the listing broker, unless otherwise specified in this agreement. We do know that more and more we're starting to see a few cases where attorneys or settlement providers are holding the deposit. That opens another whole can of worms that we'll talk about in a little bit. But this form has been created so it's more palatable for these type of arrangements now. So you could check listing broker or buyer's agent, either one holding. If you check neither, it's the listing broker. That is a change. Also changed, the next highlighted in purple here, you'll see where my cursor is. All we changed here is it used to say at settlement that funds will be paid by buyer at settlement shall be in, it used to say cash, certified check, cashier check. Well, nobody brings cash to the settlement table anymore. I say nobody, I suppose somebody might, but most attorneys do not want cash. Nobody wants cash at the settlement table. So we have actually removed or deleted the word cash at settlement. So no longer is the buyer to bring cash, they're to bring one of the other things that we previously had, certified check, cashier's check, etc. Now, then we move on. We go down to the included items. And all we did here was we added these 4 sections or 4 highlighted lines that you see so that this mirrors up with the seller's disclosure. We've done that on all the forms, tried to keep it so it's mirrored and consistent across the board on all of the forms. Now I'm scrolling down. The next change is in section number 10. disbursements of deposits. Remember, we talked a minute ago about who's holding the deposit. Now, it says the parties to this agreement agree that deposit monies held on account by a licensed Delaware real estate broker, hereinafter referred to as escrow broker, will be dispersed under one of these conditions. The reason we said that is because we said earlier the listing brokers could hold it or the selling buyer's agent could hold it. And we wanted the buyer's agent, if they were holding it, to have the same right to use the passage of time language that the listing brokers previously had. Remember, it said the listing broker could disperse it based on passage of time. Well, what if the buyer's agent's broker is holding it? Well, they should be able to disperse it in the same way. What though if it's an attorney holding it or someone that's not a broker, a Delaware licensed real estate broker? That's why we said a Delaware licensed real estate broker. We refer to them as the escrow broker now. If it's someone other than a licensed Delaware real estate broker, like an attorney, a settlement attorney, this language doesn't apply. So if you scroll down a little bit, we said down here under deposits held by non-broker, buyers and sellers understand disbursement of deposits not held by a Delaware real estate broker are not necessarily done in compliance with the language set forth in this section. In such instance, buyers and sellers are advised to consult with legal counsel. I think a lot of times agents say, well, we'll just let the attorney hold it, but there's problems there. You're opening up a can of worms. They're not bound by our real estate statutes. They may be representing the buyer and may be more prone to return it to the buyer when maybe it shouldn't be. But you also run into problems. How do we know that they get the deposit? If they don't get the deposit, say it's due in 5 days and they don't receive it, are they going to let you know? You run into problems like, hey, we'll say the settlement attorney is going to hold it. And then we contact the settlement attorney. They're going to want an escrow agreement that they have. They may say they don't want to hold the deposit, or they may find there's a conflict of interest and they can't represent the party. So here we've lost all this time and nobody's holding the deposit yet. So we encourage that a real estate brokerage hold it. The listing broker is the default, but we understand buyer's brokers hold it sometimes, so you could check either. But in light of the current marketplace, we also allow that an attorney could hold it. But if an attorney is going to hold it, you should consult legal counsel, because this section and the way this is all done wouldn't apply in that case. We also, up in the language where we talked about whoever's holding it, referring to them as the escrow broker, we said we talked about what would happen if they had a final court order to disperse it. We now say a final court order or binding arbitration order, because you're going to see later on in this agreement of sale, or you're going to see in some of our agreements, I know in the listing, in the buyer agency agreement, you're going to see arbitration being offered. All right, Andy, you stop me if you've got anything you want to add as we're going along. I'm on section 15, fair housing, just like we did with our other documents, the protected.
Hello, everyone. We apologize. We lost internet in our office. Give me 1 second. We are aware. Give us just a few moments. We're going to try to reconnect. Andy, if you could acknowledge, can you hear me speaking?
Yes, I can hear you, Wes. Can you hear me?
Yep. Okay. Give me 1 moment. It looks like our computer actually crashed.
And
All
trying
right,
to hand,
everyone, we're gonna be a little different here. We're gonna actually switch to an operating laptop that's in the room. And we'll try to get the screen back on track, but Bruce will, you'll see Bruce through a laptop instead, unfortunately. Just give us a second here.
Bruce, why don't you unmute your computer? You can keep going.
Yep, you're gonna come up on your.
Okay. Hopefully folks can hear me now. We're trying some other things.
If you could real quickly, just write in the chat if you can hear us.
I can hear you, Bruce.
Can you hear us?
All right, we apologize, but Bruce will take it from there.
Okay.
Bruce,
So,
this is it. Can you hear
I
me?
don't know if you heard, but we were doing the fair housing section, section 15, and we just added, as you can see on the screen, hopefully, other protected classes as may from time to time be added or amended by law. The next change that we made is in section 16. And all we did here is we used to talk about form 5403. Well, now form 5403 has a name or a title. It's called the Delaware Real Estate Tax Return Declaration of Estimated Income Tax. So we gave it, we used their title. That's the official title now. So we added that language at the beginning. We said the Delaware Real Estate Tax Return Declaration of Estimated Income Tax, formerly form 5403. So we've identified it with its new identity. Then I'm hoping you can see me in section 19. Good. I'm down under, you'll see highlighted and designated agents. What we did there is, it used to say in real estate agents, and we would refer to real estate agents or the broker and the agents. We now say brokers and designated agents. Now, here's a change we made. This is why you need to read these agreements. Because there are some things that have changed a little bit, and one of them is pretty substantial. It used to be, we have a home inspection contingency, a water or radon, a swimming pool, and other inspection contingency. We have a termite inspection contingency, and they all had different time things. They would say you have so many days to do this, so many days to respond, and they were different. The home inspection was 15 days, 7 days to reply, and the termite was 5 days to reply. So we've tried to eliminate the confusion and make sure that all the sections now that apply relating to these inspections all are worded similarly and have the same number of days. So you're going to find it works like this. You're going to have 15 days. You can put a different time. You can put 5 days, 10 days, whatever you want on the blank line. If you leave the blank line blank, then it'll go to the default, and the default is going to be 15 days across the board for all these inspections. The default will then be, you got the 15 days to get to the report or inspections, including supplemental inspections, and get a response back to the seller with any defects or anything you want fixed. After that, they're going to say that the seller has 7 days to respond, 7 days to agree or not agree or try to work something out. After that, if there's going to be a 2-day period in which the buyer can say, hey, we're trying to work something out, but if we can't work anything out and you're not willing to do anything, it's still a great buy. I still want the house. I'm going to take it anyhow. After that 2-day period, if they don't say they're going to take it anyhow, without any repairs or anything being done by the seller, the default across the board is going to be that the agreement is null and void. That's what it used to say on the section relating to the home inspection. But it used to say in the termite language that if nothing was worked out and the buyer didn't say they're going to take it, they were stuck with it. They accepted it as is with the defects. That's not the case anymore. 15-day default for inspection, 7 days for seller's response, 2 days to say you're going to take it or not. And if it doesn't work out, you don't reach an agreement, or you don't say you're going to take it regardless, it becomes null and void. So all those sections are now worded very similarly. That's a major change that you want to be aware of. We said in section 20, can you see my screen okay, Wes? Okay, good. It used to say buyer shall procure at buyer's expense, and then it said unless prohibited by the lender. Well, the VA doesn't prohibit the buyer from paying for that any longer. So we took that little blurb, unless prohibited by lender, we removed that. Here's where we get into our 15.7.2 and null and void. Seller shall have 7 days, not 5 anymore, 7. This is on the termite inspection, wood destroying insects. 7 days to notify the buyer in writing if they'll exercise their option to do the work. If they do, after the treatment repairs have been completed, seller shall provide buyer with a written statement from a licensed contractor certifying that the repairs required by the first structural report have been completed and the integrity of those areas is no longer structurally impaired. And it now says this report shall be provided no later than 3 days prior to settlement.
Recording in progress.
Live on screen, so bear with us. We may come back up like we want to be shortly. Do I need to mute now or?
I took that. I have to keep going.
All right. So then it goes on. If you look down here, here's where it says no later than 2 days after the aforementioned 7-day period of buyer's intention to purchase the property in its present condition. Otherwise, this agreement shall be null and void and all deposit money shall be returned to the buyer in accordance with the terms of this agreement, provided buyer is not otherwise in default. So the change is 15 days is the default now, and you've got them on all of our inspections. You'll see that in a little bit. 7 days for the seller to respond, 2 days for the buyer to say, hey, I'll take it anyhow. After that, the result would be that the agreement would be null and void. And it does say that if they decide to go ahead and purchase the property and take it as is, even though the seller's not making any repairs or doing anything, there should be no further obligation or liability on either party, brokers or designated agents, and all deposit money shall be returned to the buyer in accordance with the terms of this agreement. Now, home inspection, same thing. Our default to get your inspection. Now, this isn't, and a lot of agents think, oh, I got 15 days to get an inspection. Well, you go get an inspection, and the home inspector, who's a general practitioner, says, oh, well, you need an HVAC contractor. You need a roofing contractor. This is 15 days total, your inspection and supplemental inspections. Make sure you remember that. If you want to stretch it out longer, here's a blank line. You could put another number, 21, 30, whatever you want. The default is 15. The default now is written response from the seller due back to buyer by. You can either put a date in or the default will be 7 days, just like we talked about. 15 to report back to the seller, 7 for the seller to respond back. Buyer agrees. This is great language. We've been praised highly for this. It appears twice in the new document. Buyer agrees that minor repairs and routine maintenance do not constitute defects and are not part of this contingency. The fact that a functioning major component may be at the end of its useful life shall not render such component defective for purposes of this section. You know, we hear buyers all the time saying, well, the inspector says the roof is nearing the end of its life expectancy. You know, it's probably going to have to replace in a year or two. Well, is it leaking now? No, then it's not a major defect. You saw that when you purchased the property. So we put this language in to make it a little more clear. Then we changed a little bit of wording here. We said that, 15 days for inspection, 7 days is the default for the seller to reply. And the seller will reply that they agree to the repairs, they refuse to do the repairs, or they'll C, offer to enter into a mutually agreeable written agreement. This language hadn't changed here. And then we put the wording here, the results of successful negotiations shall be memorialized by written agreement signed by the parties. That language has been in there before. We just moved it here to line up with C. Now, pay attention to this change. If the seller agrees to correct major defects, once the seller has completed the repairs and supplied written proof of completion of to the buyer, The buyer at the buyer's expense is permitted to have such defects re-inspected by the same home inspector or licensed contractor professional. Say it was a roof contractor because a home inspector recommended a roof contractor. Once the home inspector recommends it, then the home inspection contingency allows for it if it's being recommended by the home inspector. So now we get the roof inspected, and that's where this comes into play. A contractor professional who completed the initial inspection. So the person that did the inspection can now check it and make sure the work is done. Not somebody else, but the same company or a service. Then the buyer shall notify in writing. We changed a little wording here, no later than 2 days. It used to be 1 day. It's now 15, 7, 2, and then it's null and void. It's now 2 days. If this agreement is canceled as a result of this contingency, the parties immediately agree to execute the proper documentation to acknowledge termination. And it goes on to return of deposits, etc. Here's our section 22, other inspections. This is your swimming pool, radon, water test, that type of thing. Septic system. We put language in here once again. Buyer agrees that minor repairs and routine maintenance do not constitute a defect. The fact that a functioning major component may be at the end of its useful life shall not render such component defective for purposes of this section. We put in defaults here. We didn't have this before, I don't believe. This is on the well-watered radon and swimming pool test. You have so many days to report back to the seller and request any repairs. Well, we added defaults here, 15 days. Everything, once again, I can't say this enough. 15 days for all your inspections, 7 days for seller to respond, 2 days to take it or work something out, or else it's null and void. And it's consistent across the board on all inspections. We intentionally did that. Now, seller's duties. Here it is. Seller should notify the buyer within 7 days if they intend to make the repairs or if they refuse to correct or offer to negotiate. And here it is again, the 2 days to say you're going to take it or else it'll become, as it says here, disagreement. Otherwise, disagreement shall be null and void. Now, let's get down to the stuff that you're all signed on for and wanted to make sure you understood. In section 28, agency disclosure, we realize there may be some buyers and some sellers who are unrepresented, and we've never had this box before. So we are now have a 28.5 or B here. Buyer is unrepresented, seller is unrepresented. You have a checkbox there that you could check. Now we said, here's where we're getting to the compensation part. We said in the listing agreement that we are no longer offering buyer broker compensation in the listing agreement. But it does say there that a buyer is going to go out and they're going to perhaps get representation and get a buyer's agent. We realize that, and hopefully everybody knows now, that in order, before you go show a property as part of the NAR agreement, you're going to have a buyer agency agreement in writing, some kind of written agreement. What we did in the listing agreement is we said, here's what you're going to pay us for listing your property. Here's what you're going to pay us, the listing brokerage, if we have an unrepresented buyer or another agent in the house sells it, where the buyer's unrepresented. And then we said, if there's a buyer's agent involved in the transaction, then, you might be asked to pay something. You might be asked to pay their compensation as a condition of the offer to purchase. Here's the language. It's right in the agreement of sale. Now, some states have actually done this as an addendum. We took the approach that most buyers will probably, now they may not, but I'm suggesting, I think the Forms Committee and Andy would agree, most will probably ask that the seller pay their buyer's agent on their behalf. Just like it's been happening today. They'll ask the seller to pay it because the seller's the one that's got the money. And the buyer may not have the cash. Time they pay all their closing costs, they may not have the cash. So the buyer says, I'm going to buy your property. Here's my offer. But as a condition of this offer, you, the seller, have to pay my buyer's agent fee that I owe, the compensation that I owe my buyer's agent. And it says here, section 29, buyer and seller agree that the brokers or designated agents was responsible for procuring this agreement, and that will be paid for a separate agreement. That's our listing agreement. The seller's going to pay us based on what the listing agreement says. The buyer's going to pay us based on what the buyer agency agreement says. And then it says seller agrees to credit blank, a percent of the gross selling amount or a flat fee towards the buyer's broker's compensation on behalf of the buyer at settlement. So what we're saying is the buyer makes an offer and says, here's my offer, but a condition of the offer is you have to pay my buyer's broker fee because I don't have those funds. And of course, if a seller says, no, I'm not going to do that, which is their right. But if they say, no, I'm not going to do that, they're eliminating a large portion, probably the majority of buyers, because a lot of buyers don't have all that cash available for closing costs and buyer's representation. So this allows for it. And as I started to say earlier, we put it right in the agreement of sale because it's going to be pretty much commonplace. We don't want to have to go grab an addendum, and by it being in the agreement of sale, it's more, I think everybody realizes it's more commonplace and it's the norm. And then it says, if not previously paid, the settlement attorneys hereby irrevocably authorized and directed to collect broker compensation as specified in the separate agreement and pay the same to brokers at final settlement. So the seller signs a listing agreement, says, I'll pay you this. The buyer signs a buyer agency agreement, says, I'll pay you this. The buyer now has a condition of their offer, said, I want the seller, as a condition of my offer, to pay the fee that I owe my buyer's broker. And the amount goes right here on this line. Flat fee, dollar amount, percentage, whatever. Let me caution you. You may not, per the settlement agreement with NAR, you may not get paid more than your written buyer agency authorization or agreement specifies. If your buyer agency agreement says you get 10 bottles of water and the seller's offering 12 bottles of water, you're going to have to tell the buyer that, hey, they were offering 12. What do you want to do with the other two? You want to modify my compensation agreement and allow me to have it because I did a great job? Oh, no. I want it myself. Okay, then we'll take it as a reduction in price, or we'll take it as a concession or a settlement credit, something like that. And furthermore, the way we've designed the listing agreement, the seller's not offering compensation. And if you run into sellers that say, why I'm not offering compensation, all you got to do is say, why would you offer compensation? A prudent buyer might negotiate a better commission rate with their buyer's agent than what you're offering. You're giving away money. Why would you do that? So this all works very nicely once you get your arms around it and are a little more familiar with it. But this is where in the sales agreement, if you're drafting the sales agreement as a buyer's agent and your buyer, as a condition of the sale, wants the seller to pay you, the buyer's agent, this is where they put it in, and it makes this contract contingent, or it says in this contract that the seller agrees to pay the buyer's agent's fee on the buyer's behalf. See how that works? I can't hear you, but bear with me. And then it says in section 30, this is where concessions come into play. Seller concession. Seller agrees to credit blank. It can be a percent of the gross selling amount or flat fee towards buyer's closing costs at settlement, including but not limited to any prepaid items, appraisals, inspections, surveys, mortgage fees, transfer taxes, or other fees or charges. It is the broker's responsibility to confirm with lender that the entire credit provided for herein may be utilized. If lender prohibits seller from payment of any portion of such credit, then said credit shall be reduced to the maximum amount allowed by lender. That language is in our seller's contribution addendum currently. We already have a seller contribution addendum. We may not need that anymore because it's right here in the agreement of sale now. But we've got it separated here, buyer broker compensation here. Then maybe there's an additional concession here. Maybe the seller's going to, in addition to agreeing to pay the buyer's broker fee, the seller's also going to give you $5,000 towards closing costs. So that would go here. And by keeping them separate, first off, it avoids confusion. But secondly, it also, the lenders have been telling us that, most lenders have a limit on the amount of interested party contributions, IPCs, interested party contributions that they will allow a person to give to the buyer. Normally it's somewhere between 3 and 6%. That's what the lenders said that they'll generally limit it to. In other words, a seller can't give 50% of the purchase price as a credit to the buyer. Lender says, no, that won't work. But most lenders are telling us now that by keeping it separate, that the buyer brokerage compensation will not be counted in and go towards that limit on that seller concessions. So we could have both. We could have our buyer broker compensation be paid by the seller and an additional concession by the seller. See how that works now? I know you may have some questions on that. Maybe I went over a little bit quick, but this is the section of the agreement of sale, the new agreement of sale. What happens in concept, the seller hires the listing agent, says, I'm going to pay you this. The buyer hires a buyer's agent, says, I'm going to pay you this. Buyer now wants the seller to pay his agent on his behalf. This is where that language is in the contract, and you would put it in there. Just remember, if your buyer agency agreement says you're getting 10 bottles of water or 15 apples, you're only entitled to 15 apples here. Don't put 20 apples or something like that. That violates the settlement agreement. You are only entitled to what the buyer and the buyer's agent negotiated and agreed to. Now you can modify that amount, and remember we have a form for that. We went over it last time in the last Zoom. But that's how the sales agreement, the new sales agreement, addresses these changes. Now something else we did, and this is significant, in section 31, it says buyer may not assign buyer's interest in this agreement without seller's prior written consent unless specified in section 1 of the agreement. So that would be, you go up in section 1 where it has the buyer's name and you'd put Bruce Plummer and or assigns, something like that, make it very clear that you intend to assign it. Otherwise, you can't assign this agreement without the seller's consent. It used to say it wouldn't be assigned without the seller's consent, but the seller couldn't unreasonably withhold it. Well, with wholesaling and other things and flipping and property going on like they are now, it was decided it was best to go ahead and say that you could not assign this agreement without the seller's consent, unless you said in section 1 that that was your intent. And I think that is the new agreement of sale. I mean, there's some little tweaks to it, and remember, 15 days is the default. You can do different if you want, but the default 15 days for inspection and supplemental inspections, 7 days for seller's response, and 2 days to say, hey, I'm going to take it, even though the seller won't work anything out, or to work something out, of course. After that, 2 days, null and void. That's the new agreement of sale. Andy, I'm sure you probably want to add something to that.
I think that's good on the agreement of sale, Bruce. When we're done going through what you want to on the forums, we'll talk more about some practice pointers about how maybe to implement all this.
Okay. The only other form, now you have 7 new forms that the Delaware Association of Realtors has put out. We put out a listing agreement for vacant land, a sales agreement for vacant land. Same things we just went over in the sales agreement or in the sales agreement for vacant land. Same changes. We also did a modification to listing agreement for currently active listings that are not under contract or any currently active listing. We go back and we modify our listing agreement or amend our listing agreement. We did a modification to our buyer/tenant agency agreement. And of course, we did the buyer/tenant agency representation agreement, that new buyer agency agreement that we rolled out at the last Zoom meeting. 7 new forms. You want to be familiar with them. Don't just watch this video and be done. Pull the forms out. They're available now. They're available on the DAR website. They're available to you. They were sent when you received the invitation to this meeting. Look at them, read them, be familiar with them. Maybe do some role playing, some scripts, some things like that. The other form that you're going to have to start using is an MLS form. Now, this is not a DAR form. It's a bright MLS form. And hopefully you've seen it by now. It will have to be used with all listings as of August 14th. That's a Bright requirement. And if you haven't seen it, Bright has it available. You should maybe take some Bright training and get up to speed on that. But it's a Bright form that Bright's designed to comply with the NAR requirements, and the fact that, there's no set commission rates, that you got to have a written buyer agency agreement before you go show properties from the MLS, that type of wording. I think that's the new agreements in a nutshell, and I think the main thing is now get familiar with them and let's, see how we're going to get them all to work together and work.
All righty. Andy, did you want to say anything else? We'll get into questions.
Questions, and then I can do screen share to talk some more about the practice pointers of Bruce and I back and forth.
All right, great. Hey, everyone, thank you so much for your questions. As you can imagine, we just got overwhelmed with questions. So I'm going to try to stick to themes as I usually do because of that reason. I will try to get a bunch of the ones that came in before our computer decided to crash because I still have those. So bear with us. We're going to try to get through as many as possible, as quickly as possible. A main question that keeps coming in is when again will these forms be live? Again, they will be available in all our forms providers on Wednesday. But if you want to use them now immediately, they can be found as fillable PDF documents on the DAR website, DelawareRealtor.com. I placed the link in the chat. You can find it if you scroll up. You can go there and you can pull the PDFs once you log into our website. So with that, I'm going to ask the questions as they are, and we'll go from there. Do we have to make sure that buyers agents are getting paid if that's no longer going to be part of the closing disclosure discussion?
When we list a property for sale as a listing agent, I would think you would say, here's what you owe me as your listing agent. And here's, if we got an unrepresented buyer, here's what the fee would be if there's an additional fee. The form provides for that. But I would talk with the seller and say, look, you might expect that a buyer, a lot of buyers, all buyers are going to have to sign a written agreement with a buyer's agent before they go out and look at properties. And there's going to be a compensation amount there. So you might expect that buyers and buyer's agents are going to want to be paid from the seller because that's where all the money is. They may not have the funds. So even though we don't have to decide that, we're not going to decide that. That's between the buyer and the buyer's agent. Let them negotiate that and work that out. But just bear in mind that it's quite possible when we get an offer, the offer may include the language that we just went over that says we're asking as a condition of the offer that you pay our buyer's broker. So I would review that with the seller and tell them there's a good likelihood that could happen. And if those kind of offers come in, or if there's multiple offers and they come in and some have paying for the buyer's agent by the seller, some don't. Maybe it's a cash buyer and they're paying it out of their pocket. We'll help you calculate the net. We'll take the sales price minus any concessions, minus any compensation, and we'll help you calculate the net so you can compare oranges to oranges, Mr. and Mrs. Seller, and decide how you want to proceed. So I'd have that discussion with the seller, but we're not talking about any amounts or making any offer to the buyer. That's out of bounds for us, for the Department of Justice. That's between the buyer and their agent. They need to decide that amount.
Is there a firm stance the association has on attorneys holding funds? And additionally, let me go a little more into that. Are you aware of any escrow brokers deciding who the escrow should go to? Their broker has stated that it opens them to legal issues. Why is it in the form?
Do you want to answer that, Andy? You want me to?
Sure, that's fine. Yeah, DAR does not have any particular stance or provision on that. Bruce has explained how the agreement of sale can accommodate the listing broker holding the deposit or the buyer's broker holding the deposit or some third party holding the deposit. As Bruce indicated, it's up to, if it's a lawyer holding it, what form the lawyer would want to use as an escrow agreement. I'm not aware of any particular situation of broker dispersing the money, not dispersing the money, and causing liability that way. Under the passage of time part in the agreement of sale, it's not required that the escrow broker utilize that. It's a choice. So if in the escrow broker's mind, gee, it seemed real clear, I'm really confident this is who should get the deposit money, the broker might go ahead with that based on the passage of time. If the broker says, yeah, I'm not quite sure, or there's kind of arguments on both sides, the broker's probably not going to use that passage of time part to disperse the money. They're going to say, look, somebody's going to have to file in order to get a court order if the parties aren't going to agree to a release.
Some of the questions are going to be out of order. I know that. I'm going to ask them as they came in on my screen, though. Referring to wood destroying insects, VA will not let them pay. Do you want to talk a little more about that?
It's been our understanding now that the VA has changed their position and will in fact allow a buyer to pay for those costs. That's been our understanding for the last, I think they changed that position within the last 30 to 60 days or so.
So can buyers now be unreasonable about termite issues as a way out of the contract?
If there is no infestation, no previous infestation, no evidence of previous treatment, then the contract says nothing needs to be done by anybody. And they couldn't just say, well, I'm walking away without possible repercussions. If on the other hand, and I don't want to give legal advice, so Andy, you chime in here, you're the attorney. If on the other hand, there's infestation or something and the seller agrees to fix it, they have the option and the right, they can exercise their right to fix it, in which case the buyer would still be bound to the agreement of sale, unless the repairs exceeded, I think it's 10% of the sales price. There's a section in there about that. So I don't see this being taken advantage of a lot. Basically, what it is, basically is we want to make all the language and all these inspections the same. So the default somewhere where you're stuck with it and somewhere it's null and void. If the seller won't fix it, you got 2 days to say, I'll take it, or it'll be null and void. And I'll caution you though, some buyers may say, well, I'll drag my feet and I don't care. They're not going to declare it null and void. Oh yeah, they might. So you might caution your buyer, you better make a prudent decision, because it's not unheard of that there's a backup contract for more money and they're hoping yours falls through. So you make sure you understand what it says. They got 2 days to say, okay, we haven't been able to reach an agreement. I'll take it with the defects and accept it with nothing being done. After that, the agreement says that it's null and void.
Do you mind bringing it back up on the screen? One note for everybody, there is a formatting issue that has been resolved. So the final documents will have some of the formatting issues, and a spelling correction from what you have previously received has been updated in the final documents. Bruce, if you could go down to 20D.
20D.
Andy, would you be able to cover the agree to immediately execute language from a legal standpoint?
I'm sorry, cover the what?
Immediately execute language. Agree to immediately.
Towards the end of D, 20D.
Okay.
If this agreement is canceled as a result of this contingency, all parties agree to immediately execute the proper documentation to acknowledge termination.
That's an attempt to get people to act promptly. If they don't, then that also becomes a matter of dispute.
Even though we say it becomes null and void, you still want a mutual release. And that's what we're trying to get them when we say they'll execute the proper documentation. We want a mutual release.
If a seller responds in 2 days, does the buyer still have 2 days from the 7-day period?
Now, that depends on the section, I think, as I look through it. If you look at the home inspection language, written response from seller due to buyer within 7 days of seller's receipt of buyer's written request. So, say you got 15 days to make the request to the seller. Well, suppose you do it in 7. You don't have 15 plus 7. You got 7 more from the receipt of buyer's written request. So you'd have 7 plus 7, not 15 plus 7. Did I interpret that correctly, Andy?
Yes.
And you always, if there's a question, you always want to err on the safe side anyhow.
This might be outside of this conversation, but does the FHA require a roof to have at least 2 years of life left? When additional inspections, evaluations are warranted, doesn't this fall on the buyer to have such completed?
We're not aware of any requirement like that. I don't do much FHA, VA financing, but a lot of our committee does. And they were comfortable with our language. We're not aware of any potential problems from that. If you have some, certainly send something to us.
Yeah, again, I think, as always, you know, who knows what tomorrow brings? These forms may be looked at in another month, another week, another day. Please submit any comments you have through that form that I've been sending out. I know there's a bit of questions about roof and useful life in here. That's something we definitely, we can talk about a little bit more. I'm gonna kind of skip some of those and go to some of the other
I
ones.
think that roof question comes up a lot in home inspections where they say it's nearing the end of its economic life or nearing the end of its life expectancy. The question is it performing its function? Is it leaking and keeping the water and weather out or not? And too often, I think buyers are trying to say, oh, I'm going to have to replace the roof in the next 3 or 4 years. Well, the language now says that that's not considered a defect, as long as it's working currently.
And remember, neither you nor the parties are required to use these forms. So if a buyer wanted to modify that as part of making their offer, they could write something in section 32 to modify that type of provision. It's all a matter of negotiation. By the way, while we were having the computer problem, some questions are coming to me directly, which I was trying to answer as Bruce was talking, but I'm no longer doing that. So make sure you're sending your questions to questions rather than me directly.
Bruce, if you could scroll up just a little bit to 20D.
20D?
Oh,
Am I going the wrong direction? 20D.
right there. Does the last line in 20D mean the buyer doesn't have to pay the buyer agent fee?
I think whether the buyer has to pay buyer's agent's fee, that's going to look at the agreement that the buyer has with their buyer's agent. What does it say?
Right.
And I think if you refer to that agreement, it says if for some reason, I think if the sale doesn't go through, they're probably not going to have to pay the buyer's agent unless the buyer's agent has done something to cause it not to go through. In which cases, I recall the buyer agency agreement says if it's a default or a cause of the buyer, then the buyer's agent might still be entitled to their commission or compensation. But that would depend on what their buyer agency agreement said. That's not part of this document.
Assume the buyer broker fee gets paid directly to the broker at closing. Buyer does not have to provide their buyer agency agreement to the seller? Want to talk about that process more?
Correct. And I think we'll find that some of the original thinking when TRID first came into play about a separate buyer CD, separate seller CD, that those did not need to be shared between buyer and the seller. I think we might find that's going to become more of a common practice and that there will not be the combined ALTA used either unless the lender's really requiring it. And the agreement of sale still does say that the separate buyer CD, separate seller CD can be provided to the agent or the other party. But I think we might find that more buyers want their CD kept private. More sellers may want their seller CD kept private, which is part of the original thinking when TRID came into play some years ago.
Our brokerage does not allow us to hold the EMD. Where would we indicate it to be for the attorney to hold it?
That would be up at the beginning in section number 3. Right here, if you want to, if you were to listing a brokerage and you're not holding it, you would click that the buyer's brokerage would hold it. Or if you were a buyer's broker and you wanted listing, you click here or leave it blank. If an attorney is going to hold it or third party, you'd have to specify that in additional or special terms. And that's why it says, if no selection is made, the deposit will be held by the listing broker unless otherwise specified in this agreement. So if you want an attorney or third party to hold it, you can put that in additional terms. But I would caution you to make sure they read the language in the disbursement provision that says, hey, they need to seek legal counsel before they do that.
What happens in a scenario where sellers decline to pay the buyer's agent and buyer decides to bypass buyer's agent and choose not to be represented by listing agent in order to get offer accepted?
Well, we have a protection period in our buyer agency agreement. And that's why it's there. So they don't just say, oh, okay, well, I'm terminating this agreement and I'll go buy it directly. And that way the seller won't have to pay you. I won't have to include that in my offer. And I maybe get a better deal. Well, there's a protection language in our buyer agency agreement.
And remember that procuring cause is a complicated question, and a good place to look for information about that is within the NAR Code of Ethics and Arbitration Manual. Within the arbitration section, there's an arbitration worksheet that arbitration hearing panels oftentimes use. It's 40 some questions, of points for them to puzzle through as far as trying to determine procuring cause. So don't think it's just as easy as say, oh, I'm not going to work with you anymore. I'm going to work with them and have them get the commission. This is procuring cause is still there as a question and something to be puzzled through.
I've got about 50 questions asking if the highlighted forms could be made available.
Yes, but there may be other changes besides just where I highlight. I made these highlights because that's where I wanted to focus on in this presentation. You need to read the whole agreement. But I'll be happy to, well, I already have shared with DAR and I'm happy for them to share that. I'm the one that highlighted and I'm happy for them to share that. But don't just look at the highlights and say, I know everything has changed, because there may be something that's not highlighted.
Yeah, we do send the, I'm sorry, Amy, go ahead.
Yeah, because as Bruce indicated, the forms committee, they look at every comment that comes in, and we'll probably have more comments, by next week. And we just keep all those in our computers, and Matt keeps a list and Bruce keeps a list, others keep a list. And when it comes time again to look at revisions to a particular form, we pull out those comments and look and study and talk through every comment that's sent in. So that's why there's more changes made here than just what was necessary to comply with the antitrust settlement. It was really the whole cumulative list we had up to this point. We don't want to be making changes every other month unless we really have to because of some law or lawsuit.
All right, Andy, let's talk a little about different states and how that is impacting how we've decided what to do here. And one of the questions here is, some associations feel that modifying the buyer broker agreement after it is signed could be viewed as trying to work around the intent of the NAR settlement. For example, you agreed to 8 apples at signing, and now you want the extra 5 apples the seller is offering. Do you want to talk about that a bit more, or wait to the practice part?
I'm not quite sure that I understand all the question, but as far as existing buyer clients you may be working with, I'll talk a little more about the practice pointers, but we decided not to do just an amendment to the existing DAR buyer agency agreement because we had so many changes. The thought was if somebody had an existing buyer under a DAR buyer agency agreement or a company form, you may want to think about just doing a whole new buyer agency agreement with that buyer.
A couple of questions I think I tried to answer earlier with the formatting. Again, we have fixed the formatting issue, particularly the additional inclusions. So that is corrected in the actual forms that are going to be out there.
I think the forms that you've seen on the screens today actually show the reformatting. What you received with the email that went out with the invitation for the meeting, some of the spacing was off and a few other things, but that's since been corrected.
All right. Bear with me. There's more questions I've added up here. I just want to read them before I say it.
Wes was talking about other states. You may see states like Maryland, for instance. Some of the states have taken the approach, we know we have to comply with the NAR settlement agreement. And we know we have to do that by August 17th. So here comes our forms. Well, some of them haven't, I think, thought far enough in advance, or maybe don't take it serious enough, the Department of Justice, but we do. And we have actually looked at and been following the Department of Justice comments very closely for several months now and their actions. And so we've actually, and we're not the only state that's done this. I mean, Rhode Island's done it. Some others have done this. But you may compare us to Maryland. Maryland complies with the NAR settlement agreement. But you're going to find Maryland probably does not comply, from what I've heard so far, with the Department of Justice. And they may be back to the table very quickly modifying. We've tried to make sure that our agreement not only meets the requirement that's in writing in the NAR settlement agreement, but all the things that we're hearing and seeing from the Department of Justice. And we think that's not only wise, we think it provides additional protection to your association and you as members.
What liability does the listing agent have for an unrepresented buyer asking to see a property?
Well, as you know, under Delaware statutory agency, we have the presumed agency and the presumed consent to dual agency as defined in the statute. So if a buyer's saying, I don't want representation, I'll work with you directly as the listing agent, well, then you would present that buyer with a CIS and check off that the buyer understands that you're only representing the seller and not representing the buyer and not functioning as a disclosed dual agent under the statute. As far as liability, I completely understand the question. And as part of what we were trying to do away with when the statutory agency first went into effect in 2007, and that was to do away with the implied agency relationships, because if it looks like a duck and talks like a duck, it's a duck. So if you're working with a buyer who said, I don't want representation, I understand you're only representing the seller, well, then you've got to be doubly careful as a listing agent. If the buyer starts asking you questions, well, what do you think about this? What do you think about that? Well, you're asking me for my advice and opinion, and I'm not going to give it. I don't represent you. You've made it clear you don't want me to represent you. I only represent the seller. I can provide you with factual information. I can provide you with this. I can provide you with that. But as to an interpretation of that or advice about that, I'm sorry, but you told me I'm not your agent.
All right, just refresh again. If you missed the first session we did about some of the forms, I included the link. I'll put it in there again, or Matt will put it in the chat with the video from the last session. So you can watch that. That'll cover the other forms. So the next question then is, how are retainers seen under these new changes in buyer agency?
That's a matter of negotiation between the proposed buyer and the proposed buyer broker as to what they negotiate in the way of compensation. If they want to have an agreement that says the buyer's going to pay some retainer money to the buyer's broker, that's fine. They can negotiate that. That's part of the idea behind all this, is that under antitrust laws and the DOJ's point of view and Consumer Federation of America point of view, they want to see more discussion, more negotiation, and brings me to a point of saying, I think ultimately all of this is going to lead to an additional heightening of professionalism within the real estate brokerage community. And you really need to plead with sellers and buyers to allow you to be that professional, function as that professional, take the time to explain things to a seller, explain things to a buyer, so they can be a more informed consumer as part of the backbone of all of this.
What recourse will a realtor have if it is discovered at closing that the buyer doesn't have the funds to pay the buyer's agreed upon fee?
And that's my legal question.
I mean, that should be figured out long before settlement, but that's a matter then between the buyer and the buyer broker.
Do agents need to submit amendments for sellers for signature who have signed listing agreements in place without offers or ratified contracts on August 14th?
Yes, if you have an active listing right now and it's not under contract, you need to go get a on this amendment, or you need to modify that listing agreement, because as it stands right now, our current listing agreement says you're offering compensation. Here's for the listing agent, here's for the buyer's broker or the selling agent, and we're not doing that anymore. It also allows you to advertise, or market is the word that's used in the listing agreement, that the seller is willing to consider concessions if they're agreeable to that. So they should use that form that we went over at early in the meeting today, the amendment to the exclusive listing agreement.
Are we to assume that there's still a need for mutual release when a transaction falls apart?
I'm going to say yes, Andy.
Yeah, that's the way the contract still is worked out.
You know, some people say, well, I don't need to worry about a mutual release because there hadn't been any deposit paid yet. And they think of a mutual release only as directing who's going to get the money back. A mutual release is a whole lot more than that. It relieves the parties forever and says the deal's done. There's no further liability. It's as if it never happened. It's gone. It's dead. And I mean, I think that's of tremendous value to a party, even if you're not getting any money back. At least I know now you can't come after me for damages or something down the road. It's dead. It's over with.
Yeah, now there is the broker passage of time choice, so yeah, that would be different. But as I said before, that's optional. It's not mandatory that the broker do that.
This next question sums up quite a few of them, and I know it's been covered, but let's reiterate it again. Does buyer's agent have to share buyer's agent agreement with seller's agent?
No,
No, I don't think they do. No. Now, the
And-
buyer's
and-
agent can't get compensated more than what their agreement says, but they don't have to share that agreement with anybody.
right. And it's a matter of education with the seller of saying, what you as the seller care about is your net bottom line. And I, as your listing broker professional, am going to be helping you compare different offers, and it's help compute an estimated net bottom line for you to be able to compare competing offers, where one offer might be having you pay, asking you to pay compensation to the buyer's broker, or asking you to pay other seller concessions. This one over here may or may not, or it may be different. Well, I, as your real estate professional, as your listing agent, am going to be doing a spreadsheet. I'm going to be doing some net calculations. I'm going to go over all that with you. That's part of what you're paying me for as your listing agent, is that professional advice. So we don't really care from the seller's point of view where the money's going, whether it's going to a buyer's agent, whether it's going in the buyer's pocket, whether it's going wherever, as long as it's legal where it's going. What we care about from the seller's point of view, what's your net bottom line? And I, as your professional, am going to help you compute that. That, in my view, is even more important as far as part of the value proposition the listing broker brings to the table.
Won't you need to share the buyer agency agreement with the closing attorney?
Or some communication from the buyer's broker as to how much compensation is paid to the buyer broker, how it's paid. Yes.
I would refer everyone that's asking about the highlighted versions again. There is a red line that was sent out in the email invitation to this. Also refer to that. The red line has every change that has been made. I'm hearing a lot of cons for offices charging an admin fee, and it's a RESPA violation. Do you have any thoughts or any insight into that?
Yeah, I mean, we kind of went through the go round of that years ago when brokerages started charging us an admin fee, and it's a matter of how it's explained, what it's charged for, as to its RESPA compliance. So refer to your company forms on that, which cover that.
Touching on the timeline again, so before these forms go live on August 14th or August 17th, again, we've talked about that. They're available on our website, fully in the databases at the end of this month. What is the approach someone should take showing houses and submitting an offer to the seller for my buyer? That occurs this weekend. Talked about the practical realities of it.
I would think that, the buyer/tenant agency representation agreement is out there. I think it's a good document, unless you have your own that the brokerage uses that they prefer. But I think this is a good document, and it's endorsed by, recommended by the Delaware Association of Realtors. And you could certainly use that. You could get your buyer to sign a new buyer agency agreement this weekend. I would then, if you're not going to use the new sales agreement, I would make sure when you drafted the offer that as a condition of it,
if you host an open house or provide access to a property on behalf of a seller only to an unrepresented buyer, are you required to enter into a written agreement with those buyers touring the home? No, because you're only working for the seller, not the buyer, and you don't need then a written agreement with the buyer. So our practice pointer on this is, before you open the door for that open house, make a decision about whether you are going to be only representing the seller, or if there is a buyer who expresses an interest, wants to make an offer, are you going to try to then function as only representing the seller, or explain about disclosed dual agency to that buyer and do it as a dual agent? So make that decision before you open the door for the open house. I want to get to some more thoughts here. You've seen more of those FAQs that are helpful. So now some other pointers here about how to work with sellers and buyers. I think an accurate way to describe who's paying is that the agents are paid from the transaction. For years we've thought the seller's been paying it, but ask a buyer, even in years past, who's paying the agents? Well, it's the buyer's money on the table. So really the buyer's been paying the agents, right? It's a matter of perspective and looking at that. Existing listings not under an agreement of sale, then consider a DAR amendment to the listing, or a new listing, or your company form. Some thoughts here for a listing presentation. So discuss with the seller that the buyers may make an offer asking for the seller to contribute towards the buyer's settlement expenses, seller concessions. Make sure the seller understands this is not required by law or the MLS. The Real Estate Commission is looking at a revision to the CIS to also make this real clear about compensation being negotiable. And so make sure the seller understands. Right now, you're just saying, would you consider an offer with seller concessions? Yes or no? We don't have to talk about the amount. We're not saying you would definitely agree to that or pay for that. It's just, hey, buyer, go ahead, make an offer and we'll consider it. Then the seller does not need to agree to that amount of seller concession to offer right then. It actually makes it easier then, as part of the listing presentation, for the seller to not need to decide that at that point. So help sellers understand what matters to them is their net bottom line, as I just explained, and you as a professional will help them compute that in order to compare competing offers. In my view, this is just Andy here, I'm thinking ask the seller to not tell you the lowest price they would consider accepting. That way, if you do end up functioning as a dual agent and an offer from the buyer comes in and nails it right on that lowest price, you don't want the seller thinking, oh, you must have told the buyer that. So I suggest, as part of the listing presentation, explain that to the seller. Hey, you want to sell the property? I might have a buyer. Wouldn't that be great? But do me a favor, don't tell me really the lowest price you consider accepting, because if I'm the one bringing a buyer and it happens to be at that price, I don't want you thinking I told the buyer that. Checking off yes or no on the listing agreement for the seller concession. Bruce has already explained about that. You'd be reviewing the CIS, marketing the property. There's a lot of good information you've probably been seeing as well online, some of it not so good, but there was, I think, a real good interview that Inman did with N. Zorn, a lawyer and broker from California, and talking more about how this is going to work and be implemented. So as part of his listing presentation, I'm explaining to the seller, under the new system, buyer's going to sign a buyer representation agreement before seeing your property. They're going to be the ones deciding what fee the buyer is going to pay for those services. We don't know what that number is, so we don't need to commit to any kind of number today. You as a seller just be prepared that a buyer may make an offer requesting that to be paid. And so then you'd be talking about your CMA with the seller, helping a seller understand that, here, I'm your professional, I'll pull these comps, but be aware, I can tell from the MLS, that comp that settled a month ago, 2 months ago, 6 months ago, here's what seller concessions were paid as part of that. So we need to take that into account with using that now as a comp for the CMA that I'm preparing for you on your property. Existing buyer clients with a signed agreement of sale, we mentioned do a screenshot or print the compensation offer from the MLS. Save that, because that information as of August 14th is going off the Bright MLS. Existing buyers without a signed agreement of sale, we need to have some type of a agreement you've entered into with a buyer. It does not need to be the suggested DAR form. It's just offered as a service to you. You might have your own company form. You might have a different form. You know, work that out with your company and with your broker. But if you've been working with a buyer and you've not had any type of representation agreement, then certainly you're going to need to enter into an agreement with them before touring any additional properties. And your current buyer representation agreement might not comply with all the new requirements. So that's why we've suggested from a DAR point of view, you may just want to use the new buyer representation agreement that Bruce has reviewed. For new buyers, suggesting a buyer counseling session. And this is where I mentioned before, pleading with the buyer, allow you the time to be a professional and educate the buyer. This is a complicated process, buying a home. And you no longer do we want it be, hey, it's 2 o'clock. Can you meet me at 3 o'clock at the property and show it to me? Well, I need to at least have a Zoom session with you. Ideally, you come in the office, but there's requirements, legal requirements we need to go through. So plead with that buyer to allow you the time to be a professional and educate them, reviewing your company buyer agency representation agreement, reach an agreement as to what services you're going to offer and what the compensation is going to be prior to touring homes, and make sure they know the compensation is not set by law or the MLS, it's fully negotiable. And part of the idea behind all this, and Delaware law is already very well set up for this, is it's going to all be worked out in the competitive marketplace. There's going to be buyer brokerage firms offering, you know, perhaps menu for services type of brokerage model. That's perfectly legal in Delaware, and they'd be reviewing that with the buyers. Here's my menu of services. Here's my fee structure. Let's talk about this. What do you want me to do as your professional? And so that's going to be a matter of company policy. So work with your company on that. Make sure a buyer knows that the buyer can make an offer in which they ask the seller to pay seller concessions. Personally, I would think even if there's a property that really seems appropriate for that buyer, they'd like to see it, they'd like to make an offer, I would do that even if the seller's saying, I'm not going to offer seller concessions. Who knows? You make the offer, you know, that they might like everything else about the offer and say, well, yeah, I'll go ahead and pay some seller concessions on that. Number 4 here, really help the buyer understand what matters to the buyer is the gross amount the buyer will pay at settlement. Just like on the seller side, it was the seller net. On the buyer, it's the buyer gross. And you as their professional are going to compute estimates of that as part of the buyer making an offer and evaluating counter offers from sellers. That's part of your professional service that you're offering, and really where a lot of your experience comes into play. I think that's terrific. The buyer will be pre-qualified by a mortgage consultant, so you'll have an estimate of their closing costs to plug into the gross calculation you're doing for the buyer. Similar to what I mentioned for sellers, Andy, my suggestion is they ask the buyer to not tell you the maximum they would offer for a particular property, unless the listing agent says, hey, it's time for your highest and best offer to compete with other offers. Well, yeah, we need to really talk about it then. Discuss dual agency, and will the buyer agree to dual agency or opt out of that, which could also change for particular properties. Could be then different CIS is used in Delaware. You review and sign the CIS, sign the buyer agency representation agreement and your other company forms that you have. You know, set up your tour, go ahead and represent the buyer according to the terms of the agreement. Note what was not in here. Under this, as I've explained it, you don't need to then be checking listing brokers' websites. You don't need to be calling listing agents. You don't need to be emailing or texting listing agents to find out if the seller is offering compensation to the buyer's agent. Just set up your tour. Your buyer knows that it's going to be part of the negotiations as to the compensation, and that's how it could work out well. As Bruce had mentioned, Rhode Island is gone with the kind of tear off the Band-Aid approach and complying with everything. Suggestions here again from this Inman interview part 2. You know, I commend to you, you may want to look at the whole thing online. How's the buyer's agent work going to change after August 17th? Biggest point he's made here, you need, as the agent, be properly trained and skilled in communicating about transactions, really your value proposition. You know, role play this in your office. That's terrific. And then you'll become more confident in your ability to discuss this with buyers. And so you're going to have the buyer representation agreement signed, demonstrate your value and your pricing for the transaction, explained how the process has changed. Again, NAR has a good one pager on that as well, how things change for sellers and buyers under all this. You're going to work through your presentation, allow the buyer, allow you to be the professional, and you're in competition just as you've always been. And you're not going to just say, well, on my last number of transactions, this is what I got paid or whatever. No, it's not going to, that's not going to cut it. You're going to be explaining your value proposition and how your brokerage company has their compensation schedule set, and make sure that what you're charging is consistent with your skill level, your value proposition. As I said, that's all going to work out in the marketplace. And the next thing, realize that as a buyer's agent, you don't need any help from the listing agent to decide on what's being offered or anything like that. Go show every single property, open every door your buyer wants to see that buyer is qualified for, and make an offer then on the property. As I said, it's almost easier with not needing to discuss a dollar amount with the seller up front as the compensation. It's easier not to need to get in touch with the listing broker about that. Just realize you have the buyer representation agreement that has compensation in there. You have the listing agreement that has the compensation to the listing agent. Go at it, buyers. Set up your tour, make your offers, and it's all worked out as part of the negotiation process. And so make the offer, be ready to negotiate. That's where your skills, again, as a professional, come into play, and that works out fine. So then this is what he says here. I'm not concerned about getting paid. It's part of the transaction, just like it is today. The difference is my buyer and I negotiated a buy-side fee instead of the seller and the listing agent deciding on the buy-side fee. A good closing part from his interview. Anything people in the industry should be doing to keep themselves out of antitrust trouble in the future. Yep, number one thing is get rid of anything that supports commission sharing. Don't try to be looking for these workarounds and aggregators websites that might be trying to put together who will pay what compensation. You don't need to do that. It's easier even to just not concern yourself with that, not take your time with that, not trouble yourself with that. And as Bruce has indicated, we worked hard as your state association to create forms that we feel comply with not only the antitrust settlement agreement, but with, as best we can glean, what the DOJ point of view is on this. And as I mentioned before, I hope that DOJ does file a statement of interest in order to give us even further guidance about how to go about this. There's other good FAQs I'm not going to go through all now, but within the Facts.Realtor website that Bruce mentioned. So keep your eye on that. They are updating that even more. So I have confidence in all of you as professionals in the real estate marketplace. We can do this. We can learn with this, and you'll do it much better than I would, because I'm not licensed as a broker. I'm a lawyer. You can do it much better. Role play it in your office. Talk it through. And yeah, it'll be a little rough the first couple times, but you'll get used to it, just like all the other changes we've been through. And we can work this out in the competitive marketplace. That's what it's all about. Bruce, I'll pause there. I kind of went quickly, but I know we're running short on time, and maybe you have some things to add to that.
Well, I was asked to comment on rentals and on commercial properties. And as I understand it, this settlement agreement does not apply to commercial properties. Now, we have been asked as an association previously and even recently about a commercial listing agreement, a standardized recommended commercial listing agreement. Actually, that is on our to-do list, and it's very high up on our to-do list. We've actually done drafts of it in the past, and I think you'll see that coming out in the very near future. I think that's 2 or 3 or 4 on our to-do list. It's a pretty needed form. And don't be surprised if we do a DAR commercial listing agreement. The one that I envision personally could be used for to list it for sale or for rent or for both. Because that in the commercial world, that could apply. But don't be surprised if it's not worded very similar to this agreement and it doesn't offer any compensation to the buyer or tenant's representation side or buyer or tenant agent. It'd probably be worded the same way. But we are working on a commercial listing agreement. In the meantime, you could use your own, or you could doctor up something like we have here on this residential one. On rentals, on year-round rentals, what's going to happen, as I understand it, when you go into the MLS, if the year-round rental is put on the MLS, there will not be any field for compensation to the tenant's representative any longer as of August 14th in Bright, or as August 17th on any MLSs that are affiliated with NAR. So August 14th, those fields will go away. You need to make sure your landlords are familiar with that you're not, and you should probably, if you've got that in your rental authorization agreement, you probably need to do an amendment to it to say, you know, we're not offering compensation any longer to a tenant's representative. Also, if a tenant wants representation, or before a tenant's agent goes out and shows property, say I've got a rental for rent, I represent the landlord, and you were representing the tenant, before you showed that property that was on the MLS, you would have to have a written tenant agency agreement. We have that. We have a buyer/tenant agency representation agreement. It was designed so to accommodate that. And I suppose in that agreement, the tenant's agent and the tenant could negotiate what's going to be paid. And I suppose that in the lease, if it's being prepared by that representative, they could incorporate language that said that the landlord will pay the tenant's fee on their behalf. Nothing prevents that. But you need to realize in the MLS, there's not going to be any offer in the MLS of compensation to a tenant's agent as of August 14th, whether it be commercial, residential, whatever. That field's going to be gone. It's non-existent. So you want to modify your agreement to reflect that.
I think that's good. I think that's good, Bruce. And I just want to add here before too many more people leave. Yeah, we've done the best we can interpreting all this. Since March 15th, early morning, when our phones and computers started blowing up because it was news to us as well. Our understanding of all this and our practice pointers and everything have evolved quite a bit since then, and will continue to evolve. So we'll continue to do the best we can to keep up with all this and to provide you with updates as they become pertinent. And as I think we've already indicated, don't be surprised if in 2 months we're back here revising the forms again, but we're doing the best we can to keep up with it and to think about our evolving understanding of how all this is going to work out in the competitive marketplace. We're doing the best we can.
I do have one question for the both of you. I do want to make a couple comments first. Just so everyone is aware, once more, our forms in the forms providers will be available on Wednesday. The PDF fillable versions are currently available on our website at member forms on that page. I will also mention that, you know, as Andy just indicated about the kind of the timing, the forms committee met 17 times this year to get these forms finished. So that they were hard at work. So please thank them if you see any of the members around, Bruce and Andy. A lot of effort. It's around 30 hours of time that's been poured into this.
Some of those meetings were 4 hours long. That doesn't include research time and all to the side.
Or staff time.
Yeah.
A lot of emails in between, and we have no idea how Matt kept up with us with making all the changes. A lot of them right on the fly during the meetings and everything, and looking at thoughts and changes. So we thank you as well, Matt.
So we will be sending out a recording, unfortunately, due to the computer issue we seem to have had today. There's going to be a split because the recording cut off when our internet went out. But the contents of this whole presentation will be available. We'll put it all in a single email. There's been requests for the highlighted versions. There's been requests for Andy's particular language that he just shared on the screen. We'll compile that all into a single email for everyone's use. And the recording will be available eventually on our website, so you can see it right next to the other recording. I do want to ask one final question that we have. It's a practice question, and then we'll conclude. Andy, Andy, I think, what kind of language would you incorporate into the buyer agency agreement if the buyer cannot or won't pay the buyer agent, but rather needs the compensation negotiated in the agreement of sale?
Well, you'd have your compensation part specified in your buyer representation agreement and then discuss with the buyer, well, we will make offers that include the seller paying compensation to me as your agent. We will know as part of the negotiations if the seller is agreeing to pay that or not. And then again, go through what really counts is the gross amount they're paying, and you will help them do that calculation for any property they're making an offer on. So they can not have to fret over it too much right then. It's all going to be, you're going to guide them through that as a professional.
Thank you, Andy. And in the chat, I put the link once more for the website that has the access to the PDF forms as well as the forms providers that we license our forms to. At the bottom of that, there is a comment box that you could submit any comments, suggestions. If I did not get to your question, and I would encourage you, because I did skip ones that are more broker centric, if once you talk to your broker and if you need further assistance, feel free to put your questions in that same chat box. It will go to the forms committee and we'll put together some sort of FAQ after the fact. Further, if you ever see any misuse of DAR forms, if you scroll down even further on that same page, there is a form to fill out to report illegal uses. We do copyright our forms. They are legally protected. And Andy, I don't know if you want to talk a little more about that briefly, and then we'll close out.
Yes. Yes. So Matt's been a real quick study on the U.S. Copyright Office website, registering each of these forms with the Copyright Office. So that gives some additional protections in the way of potential statutory damages if somebody uses the forms unauthorized, and collection of attorney's fees that would be charged on behalf of DAR, which, by the way, wouldn't be me. It would be a very high-skilled intellectual property lawyer who probably charges like $1,200 an hour. So you don't want to misuse the forms. Comply with the copyright.
And these are your forms, and they are only for member use. So please, help us do our diligence in making sure they are used appropriately. And with that, thank you all for bearing with us for our breakdown of internet today and our computer. Andy, Bruce, thank you so much for everything for today. Thank you to all the members that stuck with us for these 2 full hours. We appreciate you joining us. And again, always feel free to reach out to us here at DAR. We're here for you. You're our members. We are here to help you in your businesses. And with that, everyone, please take care. Have a great day.